This is the plaintiff's motion for appointment of a guardian ad litem. Plaintiff is present, represented by Attorney Julian M. Ferris. Defendant is present by the Zoom application, represented by Attorney Byron J. Conchu. Ms. Ferris, you may proceed.
Thank you, Your Honor. This is also my client's objection to the friend of the court recommendation, and with regard to that, we are
Jessica,
As to that, we are just objecting to the automatic entry after 21 days. We do have mediation scheduled with Judge Tebow on March 26th, and we would like to mediate all issues and hopefully reach a settlement on all issues and not have to piecemeal it by arguing the friend of the court recommendation at this time. And as far as
when you say all issues, are we talking custody as well?
Custody, parenting time, all the property, we're going to mediate everything. So we would just ask that it not automatically enter at 21 days.
I see. When is the mediation scheduled?
March 26th at 10 a.m. here in the courthouse.
I guess that begs the question, if there's a possibility of settlement, do you want to hold off the GAL?
I do not. I feel that the guardian ad litem would be helpful for both parties as well as the guardian ad litem, and if it's not resolved, it will be, I believe, very necessary for the court. There's a situation of abuse alleged. My client hasn't seen the kids in over 6 months. I think it's in the kid's best interest to be appointed an attorney so that someone has the opportunity to speak with them and see how they're feeling and see how things are going.
What about the cost involved?
I was wondering if the IVD fund could pay for a guardian ad litem.
I don't believe so. No. It's going to be borne upon the parties of the court entries.
That is okay with my client.
And in reading Mr. Conchu's response, doesn't sound like they have money for this.
And my client is also unemployed and indigent, so, but just in light of the circumstances of this case, guardian ad litem would be beneficiary, and I believe it's necessary.
Thank you. Mr. Conchu, how do you respond?
The court is accurate in noting that it's financially impossible for my client to incur any additional expenses on this matter. And I do note that the front of the court did prepare an exhaustive report over 20 pages, and it appears that they have extensively gone through all the custody factors and interviewed the parties involved. Also, it indicates that they did consider the preference of the children. Obviously, that's not what their preference was is not reported, but it appears that the front of the court has done an extensive, exhaustive role, sort of like a guardian ad litem, and I don't think that the expense would justify the result of what a different independent guardian ad litem would do.
What is your position relative to the objection in front of the court recommendation and the idea of having this mediated?
Well, the front of the court recommendation, again, was very, very thorough. It looks like they've covered all the issues. If we go forward, it's almost like relitigating, but we have agreed to mediation, and I do believe that the front of the court recommendation is very objective, and they did a good job of it.
And for the record, I don't know what the recommendation is. I don't receive it until it's received in evidence. Well, you've made a recommendation.
Mr. Holdwick,
Mr. Holdwick
made the recommendation on behalf of the court office. But Mr. Conchu is correct. It is a 20-page recommendation that looked at all of the custody's best interest factors and factors.
So, when is the objection period up?
I do not. I'm sorry. I know Ms. Ferris's objection was filed timely.
But I'm assuming you're not asking for a hearing today, you're looking at a hearing down the road.
Correct.
You're just preserving this.
Yes, I don't want it to just automatically enter as an order. It was filed on the date of the recommendation is December 28th.
So the objection's timely filed, so that's not an issue.
It states unless a written objection is made within 21 days that this will become the final order of the court. And that's what I'm asking the court to hold off on making the recommendation a final order and allow the parties to mediate further.
Okay, and what's your objection? I'm assuming you're listing the reasons you're objecting.
I just objected to the entry of it. My client, without my knowledge, did file also a timely objection that was several pages long, and I can file a more accurate objection. I am hopeful that we can sort something out, like I said, in mediation, and won't have to litigate the issue.
All right, whenever there's an objection filed to a front of the court recommendation, it's been, and actually it's required that you have to state the reason of the objection as well, but it sounds like your client already did that also, correct?
That was provided to the front of the court office. It was not entered as a filing in the court file because Mr. Lincoln has an attorney of record.
Got it.
Okay. You know, at this point, I am just objecting to the automatic entry based on the fact that we have mediation scheduled.
Any comment, Mr. Conchu?
Only again that the recommendation seemed reasonable, and my client had also begun to follow the recommendations of the front of the court recommendations regarding counseling and therapy for her and the children. So she's well on her way to complying with it, should it become an order.
All right, well, the alternative, I guess, would be just status quo until Judge Teeple gets involved in mediation.
Correct.
That's what you're looking at.
Yes.
And I'm assuming, Mr. Conchu, you have no objection to that.
No, Your Honor.
Okay. All right. Prior order shall remain in effect. The objection is noted relative to the front of the court recommendation, whatever that recommendation is. Relative to an appointment of a guardian ad litem, the only way the court will do it is if parties split the cost. And Mr. Conchu, on behalf of his client, claims the inability to pay. It's fair, it's in part alleging the same thing, that Mr. Lang is not employed, but there are no court funds available. So you agree to split the amount? It's fair.
We do agree to split the amount.
Mr. Conchu, any comment?
No, my client's not in a position to agree to split the amount of the guardian ad litem, especially in light of the yeoman's work that the front of the court has done.
Well, you know what, at this point, court's going to take the motion for appointment of a GAL under advisement. And the court will continue that until after the mediation. If the mediation does not prove truthful in any way, shape, or form, then we'll revisit the issue. And frankly speaking, if it doesn't, if there's no resolution to it, then the court will appoint a GAL at that time.
Okay, thank you, Your Honor.
Thank you, Your Honor.
Yes.
Well, now to proceed, parties are present. On behalf of Mr. Keys, this is Attorney Tammy W. Salins. The moving party, Ms. Welshner, appears in pro se. Would you both please raise your right hand?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Thank you. It is my understanding that since June 17, 2020, the parties have joined legal and joint physical custody, and the parties exercise custodial time week to week. Is that correct?
Correct. That is correct, Your Honor.
Thank you. And Ms. Welshner, why are you requesting a change in school districts?
Sure. Okay, I feel that this change will benefit our daughter significantly in a number of ways. North Huron has more academic as well as extracurricular opportunities for her, as well as the rest of my children.
Which school is she attending for?
She currently attends. Her 4 brothers will all be enrolled at North Huron in the fall. I've been employed at North Huron School for 5 years, so I've seen firsthand the opportunities that they provide, and she will certainly benefit from being at that school, as well as having me at the building as well for support. I waited to motion for this until all of my children are ready to move schools, as well as move to a larger home that's more suitable for all of us.
And this is for next year?
It would be in the fall, yes.
I should
Yes.
say the fall.
Yep, correct. We do have a new home that's located in Fillion, where each of us is going to be able to have our own space. We're all really excited for the change of home over the summer, and then being able to settle in for the new school year in the fall where we can attend all together. I'd be glad to elaborate on the opportunities that I see at North Huron for her, as well as respond to any of the concerns that Kevin has expressed about his parenting.
The first thing I'd like to know is what's the proper cause or change in circumstance, and also, what I also need to know is, I believe father lives in Sebring.
Correct.
And if you're going week to week, and you're traveling all the way from Sebring, Kindy, on a daily basis, every other week, that's concerning to the court as well, but explain to the court the proper cause or change in circumstance.
We're moving to Fillion. I also work there, so I feel that that's beneficial to her to be at the school where I'm employed, as well as just the extracurricular and academic opportunities that are available to her. This year, I feel especially that she was held back. They have mixed classrooms there, grade-wise, and Ren is very bright, very bright.
Again, please don't refer the child.
Oh, I'm sorry, yes. And was in a classroom where she was placed with the younger grade of students, as opposed to being able to be in a classroom where she would be challenged. As she's getting to the age that she could, participate in extracurriculars and take on hobbies and clubs and things, those opportunities are just not available to her.
And my next question would be, even if this, assuming that there is a change, how in the world does the child get from Sebring to
Sure.
Kindy every day?
Yeah, and I have already looked into that. TAT is available. North Huron, I've spoken to the superintendent, Martin Trout, has been in touch with Ken at Area Transit to find a way to arrange come fall. Obviously, schedules would change, but he's very aware of that situation and makes sure that anyone is going to make it to school on time. I also just personally took it upon myself not waiting to hear from TAT to see if I have anyone in my family or close family friends that would be available to help with transportation. And I do have a cousin that is willing to do it, as well as a local errand service that for hire that would sign a contract to be able to transport her every day.
The child is 8, correct?
She is 8, so she turns 9 in the summer and will be 9 going into the fall.
What time does North Huron start school?
8 a.m.
Conceivably, what time in the morning will the child have to wake up to get transportation, to get to Sebring to Kindy?
I suppose that would depend if it were a busing situation or an individual picking her up. It takes 40 minutes in a vehicle. So, if I would assume if she left at 7 a.m., she could be there by 7:45, which is a good amount of time for her to have breakfast or school begins.
Anything else before I go to?
Unless you want me to elaborate on some of the extracurriculars and other things in North Huron School that has to offer over home page, I'd be happy to.
No, I don't think I need that at this point.
Sure. All right.
Ms. Higgins.
Thank you, Your Honor.
Your Honor, the court is correct. The parties have one child together. It's joint legal, joint physical custody, alternating parenting time on a week-to-week basis. And it's Monday after school until Monday after school, or 6 p.m. if there's no school. My client lives in Sebring. The defendant owns a home in Owendale. She has owned that home since 2013. The defendant's home is 2 blocks from all schools. The plaintiff's home is approximately a 10-minute drive from Sebring. Currently, the child is on the road in order to attend a negligible amount of time. She's 2 blocks from the school when it's the defendant's parenting time, and approximately 10 minutes from the plaintiff's home. We understand that the defendant is now working at North Huron Schools, and it would be convenient for her to take WK to school with her and then bring her home after school. We understand the convenience factor. However, because my client lives in Sebring, it is 34 road miles to go from his house to North Huron Schools. It's approximately a 40-minute drive, depending upon road conditions. And that's one way, Your Honor. That's 68 miles in one day. That is over an hour and 20 minutes a day that she's on the road. And that's whether she's in my client's vehicle, could be longer if she's riding the TAT bus because they have to pick her up earlier in the morning, and as well as other students, or there's an errand service. Either way, it is 68 miles a day, over an hour and 20 minutes at the best case scenario per day. You take that out on my client's week, multiply that by 5 days, that's 340 miles that this little student is going to be traveling the road a week. Your Honor, that's almost over 6 hours a week that she's spending on the road, whether it's the TAC bus or my client's vehicle or an errand service. It is not in this child's best interest to spend 6 hours a week, every other week, on the road because the defendant is now working at North Huron Schools. Your Honor, we would also indicate that this child has been in schools her entire academic career. She attended preschool there. She attended kindergarten there, 1st grade, 2nd grade, 3rd grade. She's currently in the 3rd grade, Your Honor. She is thriving academically, and Your Honor, we have report cards to present to the court showing that she is thriving academically. And although the defendant expressed a concern that a mixed class was depriving the child of something, there's no evidence to support that. There's no evidence to indicate that her educational needs are not being met because there's some students that are younger in her classroom. That's something that is being assumed by the defendant, but she is thriving academically. Would also like to point out that she has won an award and she was Student of the Month 1 year ago in January of 23. The proposed school is not in the child's school district. We're in her community. It is not in her community. She lives currently part-time in Owendale, and that is her community. And she lives part-time in Sebring, and that is her community. She doesn't live in Kindy. It's not part of her community. And that is a factor we believe the court should consider. The testimony will show that she has friends in her current school that she has been with now for 4 years, kindergarten, 1st grade, 2nd grade, 3rd grade. The testimony will show that she's active in basketball, most recently, which just ended, and future sports to which he would like to enroll her, but he hasn't had a chance to talk to the defendant about. We would also like the court to take into consideration the length of time that the child has been attending her current school, and the fact that she has been very academically successful. And I can mark these for the court if the court feels that they're necessary. So, Your Honor, according to Parent versus Parent, the defendant has not met her burden of proof. She needs to show by preponderance of the evidence that it is in the best interest of the minor child
that she attend a different school, to change her school, and she has not met her burden. And it is clearly in the child's best interest to remain at the school that she's currently at, that she has been for 4 years, where she has friends, where she's thriving academically. It's part of her community in which she resides half the time. And she's not spending over 6 hours on the road every other week. So we would ask the court to deny the defendant's motion.
Thank you. Ms. Benjamin, how long have you been working at Brook?
Ms. Welchner,
Ms. Walter, I'm
no,
sorry.
it's okay.
Wrong file.
I have,
Sorry.
no, it's not sorry. I have always, been working at North Huron, for the duration of this case. I started working at North Huron, in September of 2019.
Okay.
Yeah.
And the home in Owendale, it's been
Yes.
stated by Ms. Salins that you own the home there.
I do.
And you purchased a home then in Fillion?
I did. I have not closed, but
Okay.
I have an accepted offer. Yes.
What is the status of the home in Owendale then?
It would be for sale in the summer. Since we have the summers off, it would be my intention that we transition to our new home and put that one up for sale. I'd like to address a little bit about Kevin's concerns about his parenting time or the amount of time
Go ahead.
in busing. I did speak to him previously about this, just to see if we could have a discussion about his concerns before coming in today. And he was worried about how that's going to take away from his parenting time. And the fact that he has, as he stated, a new family that is in the Frankenmuth area, which they travel to see often. So I know that Ren is very good with long drives, and we've obviously had that discussion. I've been hoping that my children may see the opportunities
I'm
available.
going to object to this. There has been no evidence presented that there's long drives involved and again, we're not to use the child's name. And I again would ask the court to remind the defendant that WK is on the roads during the plaintiff's parenting time. I haven't heard any testimony about that.
Sure.
Well, but here's something to consider as well. This might be moot. We don't have a residence yet
Correct.
in Fillion. We don't have any information as to, I mean, we've heard the mileage, but we've not heard any offers relative to how the child's going to get back and forth and what times. That's what I'm concerned about.
Oh, sure.
But regardless, there must be proper cause or a change in circumstance. And what I'm hearing is that we're closing on a house, but we haven't closed yet.
Okay.
I mean no disrespect, but you've not moved there yet. You're proposing to move there. It's almost an advisory opinion of the court. After the closing, that might be a different story, but
Sure.
at this point, it's moot. I have to deny the motion. There's no basis or no proper cause or change in circumstance. The defendant testified that she lives in Owendale. She's been working at North Huron since 2019. I know she's been timing this at this point, but she's still not closed on the home yet. She still owns the home in Owendale. Motion is respectfully denied for lack of proper cause or change in circumstance at this time.
Okay.
That'll be all. He's now here. Mr. Shumka, we started at 9 o'clock. Where were you, sir?
I have businesses that I take care of, and it's a very hard schedule to plan for.
All right, well, core business is number one. You're ordered to be here, or you're required to be here at 9 o'clock because the court would just call the case, given everything Ms. Benjamin wanted, and then you'd be on hold.
Right.
So you need to be here on time.
Yes, sir.
Thank you. Both please raise your hands.
You solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right. Again, we don't want to refer to any of the children's names, initials only. My understanding, Ms. Benjamin, is that you had a conversation with Mr. Shumka, there may be a resolution, is that correct?
Yes.
Tell me what you believe the resolution is.
50-50.
Go a full week, but with one night overnight with the children, with all 3 children.
One overnight
Yes,
per week for the other parent?
yes, both of us. So,
Right.
yep.
Exchange times,
I would like to change it to 6, if that's okay,
6 on what days?
on Sundays.
Sundays, 6 to
Yes.
6?
Because sometimes he has been late, like, and I can't stay out that late with the kids if he's late.
What about what you stated in your motion regarding issues in the home, Mr. Shep?
I mean, he has he has sent me proof that he is clean now. I
What
mean,
about the other individual that was involved, allegedly? This other person that was allegedly watching the children.
I do believe that he should not be allowed in the home while my children are there. I would really prefer that him not be in the home while my children are there.
So you don't have any concerns under those circumstances?
There has been times, yes, but he's sent me proof that there is no, like, that he has taken tests and they came up negative.
Yeah, I'm just looking out for the best interest of the children.
Yes.
If this is what you think is appropriate, I'm gonna ask the same of the defendant as well.
Okay,
So that's what you want to do, joint legal, joint physical for all children. I'm assuming alternate holidays. You be parent A, father be parent B, exchange is Sunday 6 to 6, one overnight during the week. If you cannot agree on the overnight, what day of the week would that be?
I would do Wednesday, if that's okay.
I'll ask the defendant when the time comes. And then the matter referred out for support relative to the arrangement, right?
But I'm sorry.
Support, we have in front of the court, we calculate support based upon the arrangement that you are proposing.
Okay.
Anything else?
No.
All right. Mr. Shenka, did you come up with an agreement then with plaintiff?
It's definitely an option. And it's, for the most part, yeah, it should work out fine.
So let me ask you this, though. She wants to have, for all the minor children, joint legal and joint physical, where you'd have both equal decision-making power regarding everything from medical, religious, education. And on the physical end of it, it would be Sunday to Sunday, with one overnight with the other parent during the week. If you cannot agree on a day, the court would have to find a day. It'd be Sunday 6 to 6. That's what she's proposing. Also, alternate holidays as well. She'd be parent A, be parent B. And then support would have to be recalculated based upon the amount of overnights each party gets. Is that it? Sounds like Ms. Schultz?
I didn't hear the court indicate that if it was considering the no contact.
Oh, yes, I forgot the note, and also no contact with someone named Tad regarding the minor children.
I mean, if I get, I mean, obviously, I guess I should get to say something, but yeah.
Well, that's what I'm asking you.
Oh, yeah, I mean, like, I don't feel like there's any need for any restrictions, that's for sure. There's definitely never been any evidence or any issues presented. You can't really just hate somebody because you hate them and try and control somebody else's life.
Well, I don't think it's a matter of hate or anger. It's alleged that this individual has a controlled substance issue. Notice I didn't read the last name.
Well, there's definitely no evidence or any where that should even be in play, because what controlled substance charges or how are these controlled substances being found, or what does it even persist of? Just somebody he say, she say?
Well, she's saying yes, and you're saying no, so I have nothing.
Right. So if there's no evidence, then I don't know how you can blame somebody for something.
Well, the motion also indicates that the plaintiff personally observed you and this individual smoking methamphetamine together?
Absolutely not. And if there was, there would probably be proof of that. I have 0 drug charges or any.
I'm not pointing at you. I'm not pointing at you. We're referring to the individual identified as Ted. Because mom has no concern, according to her, regarding you, but does have concern regarding someone named Ted.
I mean, I guess we can point fingers and we can have concerns about anybody, but in all reality, you know, Ted's never ever even came close to being harmful to any of the kids or done anything to present harm in any way, shape, form, or how, besides be there for help.
Okay, do you agree with the 50-50 of all children, joint legal, joint physical?
As far as like, when the other person works, like babysitting time, could it be obligated to like, so I can watch the kids daily. Like I work from home.
Well, if both parties agree something, you know, we just set the baseline here.
Right.
If you want to set up another arrangement, that's fine, but it's not court ordered. So in other words, what I mean by that is we set the baseline, and any time the parties mutually agree, if you both agree on something that's different, court's not going to stand in your way. Right. But I'm not going to get into the business of having, if one party can't have the child, then the child or children have to go directly to the other parent. That's been a disaster in the past. It takes communication between the two parents to do that. But do you have any objection to 50-50? As stated?
No, I guess that'll be fine to know.
Okay, you believe it's the best interest of all children at this point?
Absolutely not.
No, then what do you want?
I mean, technically the kids should be at their house where they know where home is and they can be watched and taken care of and raised every single day.
We have a child that is breastfed, correct?
Yes, my youngest.
Kind of.
Kind of? Okay.
She hasn't been fed all week.
I'm making a decision in this case. Parties shall joint legal, joint physical custody. For the holiday schedule will be adopted by the friend of the court plaintiff, adopted through the friend of the court plaintiff, parent A, father's parent B. Each party shall be awarded one overnight during the week of their non-custodial time. If the parties cannot agree on that day, it will be Wednesday. And what time does that usually start?
I guess I could probably pick them up after work at 4. I gotta work at 4.
4 p.m.?
Yeah.
Does that work for you, sir?
I like 7 o'clock, like we tried to do the first time. And,
Your Honor, I work in Bad X and he lives in Bad X and I live all the way in Caseville, so it wouldn't be feasible for me to come back
What time do you get off work again?
at 4.
Pickup will be 4:30.
Okay, thank you.
Wednesdays 4:30. The next day, the child, obviously, the children will be going back to school.
Yes.
If there is no school, return back to the other parent at what time?
4:30.
4:30.
4:30. Very good. As I stated, joint legal, joint physical, Sunday 6 to 6. Any other time the parties mutually agree. About the holiday schedule, support will be recalculated. Michelle, what else is important regarding at least this framework?
The court is ordering that the additional children be added to this one.
Yes, absolutely.
I do have a question. If Ms. Benjamin could stop at the front of the court office before she leaves to provide the full name, date of birth, social security numbers.
Yes, yeah.
Did you have a question, Bob?
If he's late, how late do I have to stay?
That is a question that I'm not going to answer. It's a reasonable time.
Okay, because
But part in applicable support will order as well. No derogatory comments. No addressing of adult topics with the children or around the children. And relative to the request of the plaintiff regarding someone named Tad, court will order that Tad, and I'll provide the last name. Is off limits to the children. Court finds that this arrangement is in the best interest of the minor children. Make sure friend of the court keeps up to date of your address for employment, change of employment. Ms. Schultz, anything else?
Friend of the court had already started a review process as it relates to child support. Does the court wish for us to keep the same effective date based on
Yes.
the initial?
Yes. As I understand it, the parties have joint legal and joint physical custody. They exchange week to week. Is that the understanding of the court as well?
Yes, Your Honor, we exchanged maybe on Mondays.
Fridays. I'm sorry, I apologize. It's Fridays
Fridays is the exchange time.
after school.
My order from 2022 as custodial time will occur on a weekly basis with exchanges occurring on Mondays.
We've been
That's not
doing,
accurate.
we've been doing Fridays.
We can update it if
We've been doing Fridays for the past, what, couple years now, or so?
you wish to have it modified to Fridays.
That's
Yes.
what we've been doing, so that's fine with me.
It says in the school, yes.
Ms. Schultz, if you can make that correction, appreciate that. Well, if we're going week to week, what's the issue with parenting time? So,
It's affecting her schooling, so I
well,
filed.
did we have this issue before about getting to school on time?
We did, Your Honor.
Is it coming back again?
Yes, Your Honor.
Tell me about this.
So I get an alert every time on the email, I get a text message sometimes, and I get a call from the school when the child is absent or tardy. There has been several phone calls, emails, text messages, and I received a letter in the mail that had a list of, I believe it was close to like 11 days. She's been.
Tardies or absences?
Some of them have been so late, over an hour late for school, that it's marked as an absent.
How old is this
So
child?
she's 9. So I called him and I told him, hey, this is not acceptable. We've already been to court over it once, and I'm not gonna allow it to keep happening. Her grades are starting to drop. They're at C's now. It's affecting her education. I walked into the school and talked to the principal and a couple of her teachers. And they said when she comes in that late, she's frantic and rushed. So she's not able to even have breakfast. She's not able to focus on her studies. She is not in her normal routine. It throws her off completely. Her grades are starting, I'm sorry,
Which school district?
she goes to Lakers.
Okay.
It's starting to affect her grades, and that's what's really upsetting me. And it's more of a future thing for me too. Like, we're supposed to be helping our children learn how to be productive members of society, and teaching her that it's okay to be an hour late all the time is not going to be something that's going to be good for her. I mean, besides affecting her education, it's a learning behavior that needs to be adjusted. And I'm really disappointed, and I don't want to file papers. So I told him, I said on the phone, one more time that she's even 5 minutes late for school, and this was a Friday, so he had just gotten her. And I had called him when I received that in the mail. He was to take her to school that Monday and have her to school all week. She attended school on Monday over an hour late. I grabbed my papers and I filed them. The following day, on that Tuesday, she was late as well. Not quite an hour, but she was late. The school starts at, I believe, 7:40. There is no reason. It's been like this. There's no reason to be over an hour late for school. Or any late. If you know it's road conditions, you live in Michigan, I get it. But if it's a consistent pattern, something needs to be changed. Wake up earlier, leave earlier. Her education is of high importance. I'm sorry, I'm very frustrated over this. I
You
apologize.
need not apologize. Everything I'm hearing is frustrating in court because this issue has come up previously, and Mr. Curtis was warned. I'm allowing him the opportunity to respond, but anything else before I go to Mr. Curtis?
I do want to admit to the courts that she was late on one of my days.
they had changed the bus stop for our house. It would have been the first day back from winter break, so I think it was January 3rd. They had changed the bus route, and the bus driver got confused and did not stop because the children at the bus route were messing with the back neighbors' swing set and stuff. So they had changed it, not informed any of the.
So you had one lady.
I did,
How many is Mr. Curtis had in your opinion?
all of the rest of them.
How many is all the rest of them?
You have the paper in front of me, I did not bring it, I'm sorry. I forgot it. The secretary, wrote a little note at the bottom, said that she does not always have dad come in to sign her in, but when she gets there, she asks who brought her in, and she says, it's dad. So she said from now on, just in case, this didn't go the way that was what I'm requesting, then she's gonna start marking in more, if he doesn't come in and sign her in, and she signs herself in, who she says brought her, dad, mom, so that it's more of a official document that I can provide to the courts.
But it sounds like the letter was provided to you.
Yes.
Okay. Mr. Curtis, what say you about this?
Yes, sir. A few things that Ms. Lundgren did not mention in the courts, to the courts, and I felt like holding back information is also lying to the courts. She called me up one day asking if Miss Sissy can skip school. I allowed it because I'm not here trying to.
You allowed?
Well,
the other
I couldn't say no. She
You
called.
couldn't say no.
I could say no.
Joint legal custody.
I could say
You
no.
could say, you know what, she needs her education. I remember when the judge chewed on me last time for not allowing her, for not getting the child
Yes.
there on time.
Now, here's what she also mentioned in the conversation, is that now I know you're gonna go back and tell the courts this. Absolutely. And one other thing, she's on the honor roll. Our daughter is very bright student. She has A's. For her to say she has C's, not once. She's on medication. She's been flip-flopping medication throughout the few years as well. Also, Your Honor, I cannot make this up. She calls me at 6:30 in the morning, asks if Sealy is in the trees. We're over here on speakerphone, brushing our teeth, getting ready that messes up our day, Your Honor. That's not something you do. So for her to be concerned, and because she said LifeLock 360 says Sealy's in the trees. She calls us up in the morning. She's still on me about child support. All the time about me. I mean, there's so many things with the.
I want to know
with the adult conversation.
Why is the child not getting to school on
Things like that. We wake
Like
up,
that?
life happens, Your Honor.
Life happens.
Vehicle, there was weather issues. There was my vehicle going down. I purchased a new vehicle that's more reliable now. There's Miss Limka's calling us up at 6:30 in the morning, disturbing our peace while we're brushing our teeth. Sealy don't need to hear that adult conversation. Sealy comes at me about
Okay,
child
let's not
support.
use the child's name, but
Yes,
Mr.
it does.
Curtis, when the child is on your watch, it is your responsibility to get the child to
And
school on time.
it
And
is.
this is the second time.
I apologize, Your Honor. I feel
Don't
it.
apologize to me, apologize to your child.
I do. And Sealy knows we embrace ourselves, Your Honor. When we're together, yes.
Where are you working?
I work for myself. My dad retired,
Okay.
so
What do you do for a living?
just carpentry, just,
Okay,
Still-
so you have your own schedule?
no,
No?
that's a false, that's something people think. in a
So
sense.
you're
If I
your
get
own
paid,
independent contractor, but you can't start at whatever time you want to?
no, sir, because if you're paying me to do a job and you want me there at a certain time, I have to be there at a certain time.
But the child needs to be to school first.
Absolutely, Your Honor, and I'm not here trying to dismiss any of that. I just feel like there's variations that cause it. For us to change parenting time would not be the best interest. That'd be detrimental. We lived with this schedule for a while now, and she has two different homes.
One is able to comply with it, but one is not. What
Do school.
What are you requesting that's for parenting time?
I'm requesting that she be with me for any nights before school. I guess that it would really change the parenting schedule a lot because I would still want my weekend with her so I can spend time with her. I guess it would probably right now leave him with every other weekend.
That's a change in custody.
See,
Well, see, that's what I wondered, so I went ahead and I actually filled out both papers.
Right.
And I went into front of the court and I kind of explained my situation, and I asked them, should I just file both papers? Or should I just file a parenting, like, and they were like, we can't give you legal help. I wasn't sure what to file. I guess it would more follow underneath the custody arrangement. I just want to make sure that she's with me the night before school at a decent time to make sure that she's in bed at a decent time and it's not.
This is control, Your Honor. This is about control.
It may be about control, but it's about getting the child to school.
Let's do another alternative, Your Honor.
I want to ask the friend of the court a question. Does anyone recall the warning from last night? What was it?
I believe that you had instructed parties that if this issue came up again, that this custody would be on the table.
And it is.
That's an alternative, Your Honor, please. I can't take my daughter. Even one hour. It's too much. We embrace each other. This is not just, I mean, yes, it's about school and I understand her education is important.
What's your alternative?
Something else. I wanted to come to you directly. I didn't want to do the mediation because I feel like this is repetitive on her part too. She's always taking me to court for certain things. She's always nagging about child support.
You don't have an alternative, right? Do you propose anyone?
I don't know. I don't want to propose.
Here's the court's alternative. There is a change in circumstance because of the fact that the child has been warned, or the child's not been warned, parents have been warned to get the child to school on time. There's no excuse or justification for it. The alternative would be to modify custody and parenting time. That's one alternative, but the court's going to do something rather different. Every time the child is late for school or absent from school without having a doctor's note. For instance, if the child is sick, there must be a doctor's note. Otherwise, the child's in school. Number two, if the child is late for school and there's no doctor's slip regarding an absence, then it would be a $100 fine submitted each time to the front of the court for each violation. Both parents. So if it's shown that the child is tardy, Ms. Lemke, and it was dad's time, $100.
Excuse me.
Each time.
The bus too. The bus, I understand that, but what if the bus is late dropping the kids off? Is that excused?
You are responsible to have the child to school on time.
Okay,
It
I
is
would like
your
that.
responsibility.
I would like to.
Miss,
Your Honor, I really, I would really prefer for me to get her to school. I would really.
you don't have proper cause or change in circumstance relative to custody at this point. Parenting time you may, but it's a heightened standard.
Is there anything that we can change that would give me majority time to make sure that she's at school majority of the time on time?
I don't want majority time, I want all the time.
Well, I can't promise for him, and that's why we're here.
That's right, that's why we're going to try this, and if it doesn't work, you can refile your motion.
Thank you,
This
Your
court's
Honor.
done everything possible, but I'm telling you, Mr. Curtis, I warned you last time, and this is primary, actually, no, my ruling only applies to you, not to mom.
Okay.
To you, because you're the caller here.
I agree.
Thank you. $100 each time the child is either tardy or absent. It comes up again, mom. Guaranteed, there'll be shown more than likely a change in circumstance or proper cause, and then we will modify if there's a problem showing up, because I'm tired of this child not being in school on time. Period.
We also do something about the adult talking. I got Sissy. Fine. I got Sissy coming up.
Final motion.
I just don't want to do this back and forth stuff.
I don't either. This.
I'm wondering how many times, she has to be tardy for school before I can file another motion.
That's up to you. As far as I'm concerned, one time is too many.
Thank you.
There's no excuse for justification. So that's my case, to show cause, alleging show cause violations. Mr. Dooley, parties are present. Would you both please raise your right?
Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, nothing but the truth, so help you God?
Yes. Allegation is that the father denied parenting time to mother on 2 different occasions. Mr. Holden, do you have anything to say on this?
The parties share joint legal joint physical custody, Your Honor, from the January 15th, 2021 order. On December 11th, 2023, the parties had stipulated that Ms. Atwell received every weekend parent time with the minor child from Friday at 4 to Sunday at 6, that the child remaining with Mr. Dooley during the school year, during the week, and that he would get 1 weekend of parenting time as mutually agreed by the parties. We had received a written complaint from Ms. Atwell on January 22nd, 2024, stating that she was denied her weekend parenting time for January 19th through the 21st. As a result of that complaint, a 21-day notice was sent to Mr. Dooley, notifying him that we received a complaint. He had 21 days to respond to the complaint to our office. The very next week, Your Honor, we received on January 29th another denied parenting time for the weekend of January 26th to the 28th. And as a result of 2 weeks in a row, denied parenting time complaints, the show cause was scheduled for today.
Thank you. Your explanation, sir.
Well, I had CPS actually get a hold of me, said that there was an allegation against Chastity at the time. They wouldn't tell me anything that was going on. So I told Chastity that I was denying her that meeting because I didn't feel safe sending my daughter knowing that there's a CPS case.
Well, how would you know what the CPS matters even involved?
Well, why would there be a CPS case involved in the first place?
No, please answer my question. You said you didn't know. It could be anything that bugged to.
So that's
I don't know. I'm just saying, I don't know.
I know, I'm just saying too. Either way,
So were you told by, I'm assuming that you were told by CPS not to give the children back to her?
No, they said that.
Oh, okay. So what gives you the right to violate a court order then?
Because I am the father and I feel that there was some safety measures on her part.
Okay,
And when I got a hold of her, she told me that she got pulled over with 2 kids and she got arrested because she was under the influence of medication, which I don't know, but either way, if my daughter's in that car and she got in an accident under the influence of drugs, any medication, whatever, then yeah, that would be her fault. So that is why I denied her weekend until I got proper reassurance, I guess, to feel that she was able to take her.
Well, what reassurance did you get?
Honestly, until CPS got a hold of me and told me exactly what all happened, and yeah, I don't know. I just know I didn't feel safe sending her. Plus, not only that, my daughter has come to me and told me that.
Well, we can't go to what the child said. That's yours.
Okay, well, then I guess we just keep letting it happen, huh?
I'm sorry?
I guess we just keep letting it happen then?
Let what happen?
Well, that's why I was just gonna tell you. Either way, my daughter.
Okay, excuse me. You're being very disrespectful, sir. Very disrespectful. This is a courtroom. If you want to be disrespectful with the court has ways to handle that. All I want you to do is explain what happened, why you did what you did. I'm not asking for.
And I tried to.
No. You're being very disparaging. Is the child going back to mother now or not?
Sure.
So she's had her time with the child? Or you continue to deny the parenting time?
No, I'll let it.
No, you don't understand my question. Was there another, did mom have the child last weekend?
No.
So we're beyond February, we're into, if she gets the child every weekend, correct?
Yeah, correct.
So you denied February 2nd through the 5th or through the 4th?
Yeah.
Just a moment, I'm asking Mr. Dooley. When were you informed by CPS of the allegations?
The week of 119.
Okay. Anything else?
To be honest, I just feel like if I got pulled over or anything and it was flipped on me, it would be a whole different story.
Why do you say that?
Because it's Mother's Day, and I feel like every time I come into this court, chastity gets rewarded, chastity is being heard, and every time I file a motion, she gets rewarded. I have been coming to this court the last 2 years, and I've had evidence of what my daughter has said or what has been going on, and it hasn't been heard. And everything just keeps going on and
Whatever's
on and on.
been presented has been heard, but the rules of evidence apply.
Well, yeah, I had the evidence, but no one just wanted to hear it or see it or nothing.
Just for the record, Your Honor, to Mr. Dooley's statements, he filed a motion last time that was scheduled for December 8th, 2023. And as a result of his motion, the parties agreed
Yeah, we
to the
agreed.
order that on December 11th.
Right.
If he didn't agree, he had every option to bring all those concerns to the court, but he agreed.
That's what I thought too.
Yeah, at that time, but also at the same time, I wasn't being heard. Like I got a hold of CPS last year because of some reasons, and I wasn't being heard. I pretty much got told that my daughter had to pretty much be in the hospital for anything to happen. A cop. I
Police
had,
officer, what's the name of the police officer?
I can't remember, it was last year. All I know is,
You're on county, Sanilac County?
it was Saginaw County.
Saginaw County. Okay, well, that's not a courtroom.
Yeah, I didn't say it was a court, I said it was a cop.
Well, I guess a couple things.
Let me ask this, are there criminal charges pending right now?
Yes.
Okay, what's the charge?
A OUID and a child endangerment.
Okay.
The OUID though, I do want to clarify.
Well, be very careful, because
I'm
anything you
going
say
to.
can and will be used against you in court of law.
I'm going to. It is
You've been
for
warned.
prescribed medication.
I don't care if
As-
it's prescribed or not prescribed, if you're under the influence, you should not be behind the wheel.
As of the
Do
CPS.
you agree with that?
I do. I do. As of the CPS case, it was an open closed cat free.
Cat 3.
Yes, it was open, the evidence was found to be true, however, the case was closed as there were no other significant safety concerns, is what I was told going forward. Christopher's statement is true to a point. Child Protective Services never told Christopher what happened because it does not have to do anything with the minor child, our minor child together. Also, there was
Allegedly operating a motor vehicle under the influence of a child in the car, that doesn't involve the child or
no, that I'm saying it wasn't with my child. I wasn't in the vehicle with my child.
Oh, I see.
And there was
Two other
only,
children.
there was only one child in the vehicle when it happened, not two.
Okay, well, regardless, whether it's your child or someone else's child, it doesn't
It's
make
not
any
right.
difference to me.
It's
No,
not right.
absolutely not.
It's not right. Either way it's looked at, it's not right.
Is there a safety plan put in place?
Yes,
What's the
heavily.
safety plan?
Two safety plans, actually.
What's that?
I will not drive with the children. I have released my driver's rights to myself or my children.
What does that
And
mean?
particularly, I refuse to drive with any children in the car. It doesn't, even though it's not ZA, I don't know if that will bring back any reference to.
It does.
Okay, I am safety planned to not be in the vehicle with her, driving with her. I'm sorry, I shouldn't have said not the vehicle. I cannot drive with her.
Well, that was court order.
But-
That wasn't safety plan. That was a court order.
I know, but in the beginning, that was also put in the safety plan.
Okay.
But there was never a safety plan put in play to where I couldn't drive with my other two minor children.
So
However,
you're
I
saying
have
now,
relinquished my rights and I do not drive with any children. I
so
refuse.
are you agreeing then, well, at least for a while this case is pending, that you will not operate a motor vehicle with any children in the vehicle?
Yes, Your Honor, that is exactly what I'm stating.
Awesome. Mr. Dooley?
Yeah, also, another reason why I denied her the weekend of 126 is because I was told she was at the bus stop, but she ended her car by herself.
What?
And I have witnesses.
Again, you were told, but
I have eyewitnesses. I have eyewitnesses.
when's the alleged incident to have occurred regarding the charge? What date was that?
The first one or the second one?
There's two?
Yes.
There are two incidents
There's-
involving you operating a motor vehicle?
Or no, I'm sorry, about the denial. There's
No, I want to know,
that was
when did that allegedly occur?
January 2nd.
Okay. So you missed 2 weekends, right?
Yes. Could I add?
When did the safety plan go into effect?
I don't have the exact date. I don't have my notes on the safety plan.
So this happened in early January, correct? The operating a motor vehicle?
Yes.
You got the other weekends before?
Yes, up until the last 2 weekends.
So you had January 6th through the 7th?
Yes.
There was times that you would tell me that you couldn't take her.
Hold on, I just wanted to make sure I was correct. Normally you would have January 5th to the 7th, January 12th through the 14th, 19 through 21, and 26 through 28, correct? January. Mr. Dooley, when were you advised by DHA or CPS regarding this project?
It was, I think, I didn't get told that by CPS that she was that I got told by Chastity herself. They told me that there was an allegation against Chastity and that because my daughter wasn't actually with her at that time and that they weren't able to tell me.
Well, when did she tell you that this happened?
I think it was like a Thursday night of the weekend of the 119th. It was like a Thursday, maybe.
Oh, so you weren't aware of it?
Yeah, I wasn't aware of it until I got a hold of her of the weekend before 119, and that's why I denied it because I didn't know until actual CPS got a hold of me because they still haven't got an actual hold of me to tell me what's going on.
When did they get a hold of you?
It was the weekend before 126 where I actually got to talk to them in person. They came to my house, checked it, investigated it.
The week before the 26th is what I'm asking.
Yeah, that's when they actually got to talk to me.
So again, when was the safety plan put into effect?
I'm not sure of the exact date with that. I'm sorry.
All right.
Could I please say something to the board?
What do you want to say?
He says that I didn't have anybody there. I clarified it in my motion that I brought somebody with me. I took that precaution and I still brought somebody else with me to drive. And Dustin was with me. Dustin was with me that first, not the second time, the first time he was with me. That's when Christopher's aunt, Nicole, never got off the bus. They went and picked her up from school. So that way I couldn't get her off the bus both weeks.
Okay.
Chris's aunt was very sarcastic, circling around because I waited outside of the residence until 4:30 as I was supposed to. She was very sarcastic, rolling her window down, spitting out the window, saying.
Oh, okay, I just want to know the delay, the times that you were denied. We have the third week as well, right? We may as well address them all.
What was complained for, Your Honor, was yes, the weekend of the 19th of January and the 26th of January. There would have been last weekend as well.
Right.
But we didn't receive a written complaint on that issue. The other thing is that Mr. Dooley is entitled to 1 weekend if there's an agreement. So, or do you want to take that too?
Okay. Well, you can't take the law into your own hands, Mr. Dooley.
I get that, but safety is my one
Again.
concern for my daughter.
Right, no, you don't have to repeat that, I understand that, and this is what the court is going to rule. First off, the allegation is bad enough. There's no reason or justification for it. I don't care if it's regular medication, it makes no difference. If you're not properly able to operate a motor vehicle, don't do it, especially with children. Court finds that one of the weekends, namely February 2 through 4, were wrongfully denied. January 19th through 21, bless you, January 26th through 28. I find it was proper under the circumstances. It's not an excuse. But when an issue comes up like this, bring it up to the front of the court. Do not take the law into your own hands. I find you in contempt for the February incident. Mother's entitled to one makeup weekend for the weekend of February 2nd through the 4th. The other two, there is no show cause there. Hearing that will be held. Court doesn't find the father acted inappropriately in the circumstances. So you get one additional weekend. Go ahead.
I would also request change of venue.
Denied. That'll be all.
That's the
No, sir. Other than makeup weekend, that's it.
an idea for today.
This weekend, it's still your weekend, is it not?
Today is from Friday at 4 o'clock, yes.
Yeah. Follow prior court order from me. Prior